Okay, good afternoon, everyone, and thank you for coming today. I'm very pleased to welcome you to this afternoon session, which is actually the last of our formal symposium sessions for the inaugural series of the Singapore Symposium in Legal Theory. And for this final session, I'm very happy to welcome Lorenzo Zucca. Lorenzo is a reader in jurisprudence at King's College London, where he is also the module convener for the jurisprudence course. And his work includes not only jurisprudence, but also law and religion scholarship and scholarship on human rights. His most recent book is called A Secular Europe, which brings a sort of jurisprudential understanding to law and religion issues in Europe, and that's been published by OUP. Today, Lorenzo is going to speak to us about naturalism and normativity in transnational ages, and we will follow our usual format. Lorenzo will speak for about 30 to 40 minutes. We'll have a short break whilst we turn off the recording, and then we will reconvene for Q&A after that, and we have until 6 o'clock. So with that, Lorenzo, thank you very much for coming all the way. Welcome, and we look forward to your presentation.
Well, thank you very much, Arif, Andrew, and everyone for coming today. I must start with a short apology about the paper, which, using Hobbes' terms, is nasty, brutish, and short. And the reason is that it's very much early days for this new project, and I'm trying to gather as much feedback as possible. So I'm particularly interested in what you have to say about it, rather than having sort of a fully fledged or written in stone type of views. And perhaps just very quickly to understand the evolution of my work, my first project, my first book with OUP, Constitutional Dilemmas, dealt with the conflict of values and the way in which the judiciary dealt with this conflict of values. The second project dealt with a secular Europe, and it was about understanding how it is possible to create an environment where religious and non-religious people coexist. So how is it possible to create a constitutional sort of space for religious and non-religious people? And now I'm taking this to the next level, which I call, the naturalism and normativity debate. I'm trying to see in a genealogical sense to what extent normativity is explained or can be explained, and I I distinguish in this paper one strand that I call the Grotian strand of normativity that still relies on the theological notion of faith to explain normativity at bottom, and believes in a distinctive sense of normativity, and on the other hand, a fully naturalistic perspective that does not have anything to do with the faith kind of experience. So with this in mind, I proceed with my introductory point, which starts exactly in Singapore with a fascinating case. In 1601 exactly, this boat, the Santa Catarina, a Portuguese boat, is attacked by a Dutch boat, and the booty of the Santa Catarina is then divided to Dutch stakeholders back in the Dutch provinces. This obviously creates a major diplomatic and legal issue, and a very young lawyer, Hugo Grotius, is writing a memorandum for the Dutch provinces back then. It's very interesting for those of you who are interested in transnational law, because I take it to be a fascinating case of transnational law. Here you have Dutch provinces that are completely detached from any understanding of the state. They just acquired independence from the Iberic Peninsula, and they're actually in conflict with the Iberic Peninsula. So you have quasi-state type of entities from which depends a private holder of a boat, the Dutch boat, that is a completely private actor, And this private actor is is engaging in an act of war in the Strait of Singapore, attacking another boat, a Portuguese boat. So Grotius claims that it is legal and permissible for a private agent to engage in an act of war against governments and against other private actors. Why? It is because they are simply defending their natural rights to the free trade. And this is a right that cannot be violated by anyone else. In practice, the Portuguese and Spanish governments were putting an awful lot of pressure on other states, on other boats and private individuals, not to engage in trade with East Asia. So this is an interesting prolegomena to the understanding of transnational normativity, so to say. And I have to put this in context. And the context of this transnational understanding of normativity is the 16th century religious wars, where, as you very well know, the divisions between Protestants, Catholic, and Anglican, not to mention the Orthodox and Muslim world, was already prominent. Now, if you see a certain parallel with this present type of situation, a parallel with the existence of religious conflicts, the existence of legal pluralism, the existence of widespread moral skepticism, it's, for me, certainly not a coincidence. It's actually a very relevant, interesting point to my genealogy. It's relevant and interesting because what I'm trying to show is precisely that it's in this interesting time of the world where there is this kind of conditions are met, that philosophers attempt to provide a certain type of answers to the question of the global order and the normativity of national and international law. But what is even more interesting is that scholars like Dworkin himself, in his posthumous book, Religion Without God, use exactly this language, the language of religious wars, and they distinguish between the idea of religious wars as wars and conflicts between religious people. This is one of the facts of the world out there. But more importantly, they say that they claim that there is a deeper religious war, the one between religious people and those who want to defend a naturalistic or a scientific understanding of the world. And in fact, interestingly, Dworkin, just like Grotius back then, takes the side of the religious people in an interesting twist. So he defends what he calls a religious attitude towards the world, which is an attitude that tries to take into account the fact that we human beings react to the external wonder and beauty of the world in a way that shows that there is an inherent notion of values out there in the world. And this is what he calls the religious attitude, and he contrasts it completely with a scientific naturalistic picture that claims that there is no such thing as values out there in the world, and that all there is to understand is the world understood in scientific terms. So this is an interesting and an important setting of the debate about normativity, because it's against this debate it's against this debate that Dworkin is actually and Grotius are actually providing their own answers. So the answer of Grotius to this question is the so-called etiam si daremus non esse deum, which is one of the most important aspects of his treaty on the law of war and peace. And it's the first attempt to partly detach theology from morality, Although, and the point is that Grotius is attempting to hypothesize the non-existence of God and what would be the consequences for the realm of morality. And Grotius claims that there would still be a normative order out there that is fully distinguished from the natural order, and this normative order is what guides the behavior of human beings, what ought to guide the behavior of human beings, and it does not depend on the existence of God. Of course, this kind of solution is the solution that is relevant for trying to bring the peace between different factions that are divided by God. Interestingly, if you probably see already the parallel with Dworkin, and it is exactly the same argument that Dworkin makes in Religion Without God. That is, let's try to imagine an understanding of religion that does not depend on atheistic arguments, does not depend on the acceptance of a God out there. And this religion goes back to what Dworkin calls the religious attitude. It's the attitude that each individual has, the open attitude towards a world filled with values, aesthetical, moral, and all other values. It is interesting that these solutions are essentially parallel solutions, and it's what I call the dogmatic solutions to the problem of religious wars. So in the face of deep moral skepticism, the dogmatics try to defend one domain of moral truth and separate it from religious controversies and from other possible ground of deep disagreements. Needless to say, this theological separation is not pure and perfect. It still very much assumes the existence of a normative order. So there is a dualism between the normative order and the natural order. Now, this what I call dogmatics all sign up to a normative fundamentalism, or you can call it as you want. Thomas Scanlon, for example, calls it in his last book reason fundamentalism, and it's the idea that there is at bottom of morality something fundamental and something that cannot be reduced to anything else. That is the notion of reason. But Scanlon very much agrees with Ronald Dworkin on the idea of the existence of the normative domain that is completely independent and autonomous. The normative domain is just like the domain of mathematics or the domain of science. It lives completely independently and does not need any further certification. Also, the normative domain of truth, according to the normative fundamentalist, has its own internal standards of truth. You cannot, in fact, appeal to external standards of truth. All the normative statements are connected with the internal position. And crucially, what is very interesting for me, in particular, is that Dworkin makes this fundamental claim in his booklets that in order to understand the existence of this normative domain, you have to make appeal to the notion of faith. And this is what unites religious and non-religious people with a religious attitude and against the naturalist, is that religious and non-religious people have the faith in the existence of the normative domain of values. This is the first theological premise that is somehow sneaked in or secularized in Grotius and Dworkin. And the second theological premise is the idea that in this normative domain, we can appeal to hope, well, Dworkin appeals to hope in order to explain the possibility of finding agreements between different values. The last point, the point of hope, is something that's characterized Dworkin versus many other normative fundamentalists. Most of the normative fundamentalists are now siding with a value pluralist understanding of the normative domain, which means that it's unlikely that all values will be harmonized in the end. There is always the possibility of conflicts between normative values, and this conflict entails incommensurability between different values. So this is just the hope dimension is something that's Dworkin and Grotius, by coincidence, hoping utilize in this domain. But the picture, I hope, is clear. Normative fundamentalism is and relies fundamentally on theological or quasi-theological notions that without which the existence and of this normative domain would be unwarranted. And Dworkin, in fact, says it very clearly in his booklets and in Justice for Hedgehogs. It does speak of the faith element, and by the way, Rawls also spoke of the faith element in political liberalism, and this is an element I'm particularly interested in for the following reason. The reason that I was struggling with in my previous book, and it's the question of well, what if you do not have this faith? What if you have a fundamental worry about these theological notions that grounds the existence of the normative domain? I happen to be someone who has this fundamental worry about the faith element. And what Dworkin says is that if you do not have faith in the existence of the normative domain, then you're not provided an argument against normative fundamentalist. You're just acknowledging that there is a standoff. Normative fundamentalists fundamentally believe, and the notion belief is actually confused in Dworkin with faith, but normative fundamentalists believe that in the existence, whereas others simply do not believe, and there's nothing more to be said if we were to follow Dworkin. The next question that interests me is also what does this faith element, this faith in normative standards, say about international standards? And this is something I will deal now, and then I will provide the other story, the naturalist story, in order to see whether it can be more appealing than the normativist story. So the interesting parallel again between Grotius and Dworkin, and I took these two just for simplicity of exposition, but it seems to me that Grotius is quite a good starting point for those who are interested in international normativity or transnational normativity, in the sense that he is widely considered as the father of international law, and he is more precisely considered as the father of positive international law, which is peculiarly ironic and strange for many different reasons, but the most important reason is that the notion of obligation in Grotius is a deeply local one. So Darwell has done quite a lot of work in showing to what extent the moral philosophy of Grotius is a prehistoric example of the second personal perspective. That is a perspective that relies on the relationship between two people and the existence of mutual accountability between Arif and myself, is the ground of stringent obligation. And this tells a lot about also the existence of, or the non-existence of obligations when you move away from the local premises that are characteristic of sociability. And in fact, Grotius' understanding of international law is very much prefaced by his work as a consultant and a legal officer of the Dutch provinces. So what's Grotius' work in terms of international law is not a coercive international framework that imposes stringent duties from the top down. No, what Grotius is defending is very much a thin understanding of international law, where diplomatic relations can be exercised more effectively than ever. Grotius is a diplomatic envoy for the Dutch provinces, for Sweden, for France in his career. And what he wants to do is to have a framework within which diplomatic relations work well and nothing more than that. So within that framework, diplomatic envoys have all the work to do. So it's a very, very thin understanding of international law. And it's an understanding that relies very much on natural law, in which the international law is very, very thin. And the parallel with Dworkin is with the understanding of Dworkin's associative obligations, that is the most stringent type of obligations that arise from certain type of relations and roles between individuals in the society. And what is interesting to notice is that, again, in his posthumous publications, A New Philosophy of International Law, Dworkin defends all of a sudden a new philosophy of international law that uses a little twist of sort of a very weak kind of argument, in the sense that what he understands about international law is what he defines as the international law, or as the coercive international law, is this idea of the obligation that the state, the national state, not only has within the state, but about the Westphalian system of international law. So all of a sudden, it's interesting to see that many legal philosophers wake up to the sort of call of international law and realizes that there should be a normative way of defending a role, however marginal, for the international legal normativity. And what is interesting again is that this understanding of normativity for Dworkin and for Kelsen as well, in fact, is very much a thin normativity that relies altogether on faith. Remember, interestingly, that Kelsen himself understands international legal normativity as being grounded on this idea of pacta sunt servanda. This pacta sunt servanda is a completely hypothetical categorical that does not rely on anything else. So it's something that you have to take as a matter of faith. And in fact, in Kelsen's posthumous book, A Secular Religion, he explains that it cannot be further explained. So what Dworkin, Kelsen, and Kelsen as well are asking you to believe in is to stop asking questions about normativity and just accept that at one point we have to purely accept this idea of a normative order impinging upon legal relations or moral relations. And the next chapter of this story ends with the Hobbesian final chapter that I won't go into. But to me, it seems to me the natural consequence of a view that is very thin on normativity, and sort of calls for a strong framework within which normativity or authority of the state can be understood. So all this is my the presentation of a very broadly painted genealogy of the normativity of international law, and the question I left hanging is the question about faith. So what about you? What if you don't have faith? Then what are you left with? And I try to explore another competing genealogy that goes from Spinoza to Montesquieu and to modern naturalists nowadays. And I say that there may be some interest in this naturalistic understanding of the world, something that should be explored further rather than less. The idea of the core of Spinoza's thought is not easy to encapsulate in a very short formula. Also, for different reasons, Spinoza's thought was very difficult to unpack. It was written in a very formulaic way for problems of censorship and so on and so forth. But the basic tenets of the naturalistic project can be understood against the background of normativity, of the normative project. So the starting point is the idea of Deus sive natura, that is the idea that God and nature, or nature, God is the same thing as nature, is co-eval, and nature is the same thing as God. So the point against the Judeo-Christian tradition of his time and of our time is that there is no transcendental God up there watching us and telling us what to do, either directly as Pufendorf would have it, or indirectly as Grotius would have it when he says, imagine that there is no God. Spinoza doesn't want to buy into that Judeo-Christian tradition, doesn't want to engage in the question of normativity as dictated by the will of God or the existence of a normative order. He wants to engage in the understanding of the immanent nature of nature as it is. And the second point of his project is that nature does not act on account of an end or a purpose. So against the natural law tradition, the point is that there is no teleological account of normative orders. Human beings do not account or do not act following an end, and nature do not follow an end either. So there is no teleology in the world. We just happen to do what we are made to do out of nature, and we follow natural necessities when we act. So the modality for understanding nature and everything in nature is the modality of necessity. And finally, nature is the third pillar, is the idea that nature is everywhere and always the same. That is, there is no dualism, again, against the background of the natural law tradition. There is no dualism between the domain of normativity and the natural domain. And also, men and human beings are not made in the image of God, and therefore are special or different in that name. Human beings are just like any other animals, acting, well, according to certain dictates, but there is no anthropocentrism in Spinoza. So, in other words, it's a straightforward and complete rejection of the natural law tradition. And this, of course, begs many different questions. And the first question is, what about normativity in this picture? The first point that one has to understand is that you can one can understand Spinoza by contrast to Hobbesian understanding of natural rights. So there is a similarity insofar that both Hobbes and Spinoza believe that all individuals have a natural right to strive to exist and extend their control over the world. This is rather Spinoza's formulation, but it's the idea that we have a natural right that dictates us what to do, and it is first and foremost the striving to exist and the striving to increase our control over the external world. And this is what anyone is bound to do by natural necessity. If you happen to do the reverse, it purely means that there is something wrong with your nature, in the sense that, or your upbringing. The second point of Spinoza's natural normativity again can be understood against Hobbes. Hobbes thinks that we incur binding obligations when we make pledges under the appropriate conditions, whereas Spinoza, by contrast, maintains that the validity of an agreement rests on its utility, without which the agreement automatically becomes null and void. So there is a fundamental difference in this perspective. One difference that does not grant the possibility of binding promises or contracts. The upshot for as far as the state is concerned is very important as well, and there is a very deep difference between Spinoza and Hobbes, and many people, many interpreters of Spinoza actually try to explain Spinoza in purely Hobbesian terms, but the difference is fundamental in the sense that Spinoza places the burden of political stability of the state or any other community or any other political framework on the sovereign power rather than on the subjects. So whereas Hobbes would focus on the vices of the individuals, Spinoza automatically focuses on the vices of the state. Just to bring this point home, what Spinoza says is that when there is excessive vice or non-compliance in a state-organized community, the blame must be laid at the door of the commonwealth and not at the cultural limitations or limitations of character of the populations, as Hobbes say, and many other political philosophers insist on. So the state is very much the servant of the local community, and the states exist and strive to exist and manage to exist as long as it legislates wisely and can understand the competing needs of the population on the ground. If it does not do so, it simply incites insurrection and is bound to perish and it's bound to disappear. So the state is in Spinoza is understood in a completely contingent way. It is good as and to the extent it serves the purposes, but the aims of individuals, and it is bad and bound to perish. Bad means unable to survive when it cannot respond correctly to the demands of the citizen. And bear in mind that the crucial difference between Hobbes and Spinoza is that Spinoza is the first democratic thinker, is the first who says that the democracy is the correct regime for a community, to the opposition of Hobbes, of course. And the way in which I understand the law within the Spinozian framework is another twist of my argument, in the sense that I present it, I present the understanding of law in a way that recalls Montesquieu, since I do deeply believe that Montesquieu is the most empirically driven legal philosopher ever existed. Much more empirically driven than any empiricist British philosopher ever existed. Isaiah Berlin correctly sees this, that Montesquieu is actually someone who has a very healthy and strong empirical commitment. What it means that it does not understand law in the mold of some theological commitments. It tries to understand the law naturalistically, so it's a really empirically driven naturalistic project. And the definition he provides has always perplexed many people, because, it presents the nature of law as a matter of relations between ruled and rulers, between different constituencies. But what it really means and what he wants to open up is the idea that we have to study the relationship of cause and effect that characterize the emergence of state communities or other communities and the dismissal of these communities. So he sees political frameworks, political states as biological entities that have to respond on physical and moral causes, as Montesquieu called them, meaning that you have to do a lot of empirical work in order to understand what kind of empirical effects the climate, the soil, temperature, and on the one hand, and moral culture, religion, and other traditional aspects of culture play in the formation of governments and in the relationship between governments and the subjects. So Montesquieu is very much a naturalist avant la lettre, someone who attempts to understand and explain law by using historical, empirical, and psychological, socio-psychological accounts. My point is that there is very much today a space for an account of law of this kind that has nothing to do with the natural law tradition, has nothing to do with the positive law tradition. It's a sort of a third family of legal philosophy that is still a form of legal philosophy, even though it's a legal philosophy that is deeply inspired by empirical understanding. And what does Montesquieu or Spinoza have to do to tell us about the international normativity? First of all, what I said about the contingency of the states, there is no special mystical nature to the Leviathan in Spinoza or Montesquieu accounts. Montesquieu is very much worried about the persistence and duration of the states. It gives recommendation as to how to rule in a wise way and to persist in survival, but it doesn't say that survival is a necessity if the city-states or the empire or the church that are ruling are not capable of instilling piousness, obligations in their citizens, so much the worse for them. They will be bound to perish and disappear. And it's in this context, the context of contingency, that we live nowadays, and that's my point, the blossoming of transnational and international theories confirms the contingency of the state, if anything. The point is that we are nowadays in a time of passage where the old sort of political frame of the national states has become increasingly more incapable of responding to the challenges that are present. Of course, the state will not disappear tomorrow or in 20 years' time or even in 50 years' time. There is still resilience and there is no way in which the state, the national state can simply disappear. It will become just another actor probably rather than the main political actor. I come from a state that is a completely minor actor in the international community. Italy is completely irrelevant, and we, from the Italian perspective, have a completely skeptical view on the authority of the state. So perhaps this informs my understanding of the state, but we don't see the demise of the state as anything massively strange. The transnational law story is something that comes within this understanding. So I don't think that there is nothing fundamental, there is no essentialist claim about transnational law. It is simply portraying a state of affairs that is complex and complicated. The fact that there is no regime political frame that can explain or can encompass authority in an efficient way. But transnational law does not tell us anything about how the future world order is going to look like. I don't think that it tells us anything about how relationship between authorities are going to look like. It's chiefly, as far as I'm concerned, telling us something about the volatility of the present Westphalian state of things. And we are simply waiting for the new sort of biologically fit political framework that will take that will replace the state, the nation state, as the nation state has replaced the city state, the empire and the church in Europe. So as a quick conclusion, these projects, rather than a paper, because the paper is just a sketch, well, attempts to bring back to the fore something that has never withered away, and this is the so-called theological political conflict. We have fooled ourselves into thinking that secular Western states had moved away altogether from religious ways of thinking. I think that the parallel between Grotius and Dworkin shows precisely that we rely on a certain number of assumptions when we make normative judgments that are still very much in the spell of theological thinking. And what I'm interested in is to provide an alternative picture that I hope to have just sketched is a viable picture insofar that it has a genealogical presence in the history. It just happened to be a less well-trodden path. This does not mean at all that I think that naturalism, as I understand it, is an enemy of religion. In fact, political thinkers like Machiavelli, the first secular thinkers like Machiavelli and then Spinoza, were very wary of the role of religion in a political community. Not that they were religious people, certainly not, but what they thought is that religion provided a very important grounding of moral obligations for the population at large. So if you take the Bible, for example, the Bible for Spinoza is a wonderful account of substantive moral principles. It just doesn't have anything to do about metaphysical, theological presuppositions. So if you strip the Bible from the most ambitious accounts of what the world looked like, then you're left with a very sensible story of moral obligations. And what I also wanted to say in this paper is that you have to take, and one has to take a side in this debate. And I think that the side is between those who have faith in the existence of the normative domain. So if that is the case, then be it. You have to accept that you rely still on theological presuppositions in order to understand or explain your normative judgments. I'd rather try to explain the normativity of law, the state, and international law without resorting to these theological premises. Thank you.
Thank you very much, Lorenzo.